Sir, shall we start?
Yes, Prashasti.
Good afternoon, one and all present here. I, Prashasti Srivastav, on behalf of Manikchand Pahade Law College, welcome you all in our one-week online lecture series on jurisprudence. I request our respected Vice Principal and faculty in charge, Professor Sri Krishan Morris, sir, to kindly give the keynote introduction of this online lecture series. Over to you, sir.
More sir, where are you?
Sir, I think more sir is some technical problem is there. Prashasti, you go ahead.
Yes, sir. Now I request our respected principal, Dr. C.M. Rao, sir, to kindly address the today's gathering. Over to you, sir.
So the purpose of this particular sharing of knowledge or disseminating of knowledge from all quarters is to learn something in this particular COVID-19 pandemic. So knowledge from any area, you must appreciate and digest the particular thing that is going to be delivered by all the distinguished guests from all over India. So I may teach the subject in one way, the other teacher may teach the subject in another way. So when I am teaching the subject, I too have the knowledge of the subject, but I may be wrong in teaching. And this is an occasion where I can learn something from the experts like Bhagyasri madam and other teachers who are coming to deal with the subject. The dealing of the subject is same. The way in which each teacher or each faculty or resource person is dealing is going to be different for that particular purpose. So somebody likes sweet, somebody like hot. Somebody doesn't like to listen CM Rao, somebody doesn't like to listen More sir, somebody doesn't want to listen the voice of Amul Chavan like that. But we are going to have these 6 days, and it is going to be in the particular YouTube. Wherever you want, you can go through it and you can refresh your memory whenever the occasion comes. On behalf of management and staff, I welcome all the participants, esteemed our students. I am using the word esteemed because it is the first batch. I observed more than 50 are presenting for a online lecture series. So those who are joining is don't forget that it is for your benefit. And we are taking, all the teachers are taking so much of pains in arranging these particular lectures, whether it is your subject or not. Every day one lecture is going on. Please listen to the particular subject and put that particular thing in your storage of mind, which will be beneficial at a later stage. I appeal to each one of you, please do not let any lecture unheard, whether it is in your curriculum or not. Whether it was in your curriculum or not, put it in your mind chip, and utilize whenever the occasion arises for your future. Thank you, one and all.
Thank you so much, sir. Now, I would like to take an opportunity to briefly introduce our resource person of today's session, Dr. Bhagyashree Deshpande, ma'am, who will be addressing the topic of analytical theories of jurisprudence. Respected ma'am is a professor in the Department of Law at Punjab Rao Deshmukh Law College, Amravati. Ma'am has contributed in the publication of 75 research papers in UGC referred journals, peer-reviewed journals, conferences, and seminars at national and international level, and also given the presentation of 25 research papers. Ma'am has authored 7 textbooks in law which are forwarded by the Honorable High Court judges. Ma'am has received the Best Presenter Award at Symbiosis Law School, Hyderabad in January 2020. Ma'am, we are so delighted to have you with us today. Now, before proceeding towards the session, there are few instructions for the attendees. Kindly mute your audio and the video so it could not create any hindrance in the middle of the session. If you have any question, put it in the chat box or the comment box. It will be taken up by the ma'am later. Now, I kindly request Dr. Bhagishri Deshpande ma'am to take over the charge. Over to you, ma'am.
Thank you. Thanks, Prashasti. Yes, Amol sir, shall I start now?
Yes, madam. Yes, please.
And am I audible?
Yes, ma'am. Yes.
Okay. Good afternoon to one and all. Goddess of wisdom, Mata Saraswati. At the outset, I pay my sincere tribute to Honorable Dr. Bhausaheb Punjabrao Deshmukh and Honorable Dr. Babasaheb Ambedkar. Respected Principal of this college, Dr. C.M. Rao, Vice Principal Sri Krishan More, IQRC Coordinator Dr. Aparna Kotapalle, Faculty in charge Dr. Amol Chauhan, and organizing team and students. Topic for this today's lecture allotted to me is analytical theories of jurisprudence. Of course, jurisprudence is a technical subject, and Rao sir just very rightly said that the teaching method for this subject varies from teacher to teacher, because we have to consider the jurisprudential analysis and logical interpretation of the eminent jurist from various schools. Now, all of you are aware that there are various schools of jurisprudence. Why philosophical school or natural law theory, analytical school or positivism, historical school, sociological school, comparative school, synthetic school, American realism, communism, etc. Now, when we consider the analytical theories of jurisprudence, no doubt that the most eminent jurists who have been contributed in the field of development of analytical school are considered as Jeremy Bentham and John Austin. Now, time slot allotted for me for this lecture is of 1 hour. That's why I have decided to just cover the outline of these theories propounded by various eminent jurists from this analytical school or this school, without going into much detail, because these theories are very bulky, comprehensive and exhaustive one. So when we consider the eminent jurist from analytical school, no doubt that analytical theories or analytical school is addressed with various names, that is analytical school or positive law theory or positivism or empirical theory or imperative school or functional approach of law or practical approach of law, or it is a scientific approach or sometimes it is addressed as anti-natural law. Why it is addressed as anti-natural law? Because Jeremy Bentham, who is considered as founder of these analytical theories of jurisprudence, condemned natural law theory as a nonsense one. He said that natural law theory is a nonsense one and containing various silly ideas within it. That's why this positivism or analytical school, it is sometimes considered as anti-natural law, or it is the approach which is anti-natural law. No doubt that when we consider the basic difference or demarcation between the principles propounded by naturalist, that is the jurist from natural law theory, and positivist, that is jurist from analytical approach. All of you are aware that philosophers in the field of jurisprudence, they are addressed as jurist, legal philosophers, jurist. So jurist from natural law theory, they are addressed as naturalist, and jurist from positive law theory or positivism, they are addressed as positivist. Now, when we consider the basic difference, why it is called as anti-natural school or anti-natural law, because natural law theory propounds the law which ought to be, whereas positivism or analytical school, it is related to practical or functional approach of law. Now, when we consider the eminent jurist contributed in the field of development of analytical positivism, various names are there, and we may quote some of the names of eminent jurists, that is Jeremy Bentham, John Austin, H.L. Hart, Hans Kelsen, Holland, and Salmon. Now, theme of my lecture, I have decided that I shall cover the outline of analytical theories propounded by these various jurists, eminent jurists in brief, in comparative manner, and then I shall highlight the criticisms to it as well as the applicability and significance of these theories in the context of present age or in the context of 21st century. This will be my theme. Now, first of all, when we consider, no doubt that um, all these eminent jurists, that is Jeremy Bentham, John Austin, H.L. Hart, Hans Kelsen, Holland, and Salmon, though they are from positivism, and the basic principle of analytical theories or positivism is that law is a command of sovereign having sanction behind it, and there should be separation between law and morals. No doubt that this basic principle is common to all or all of them, that is the jurists from positive law theory, they have accepted these things commonly, that no doubt that law is a command of sovereign having sanction behind it, and there should be separation between law and morals. All these eminent jurists, they were ready to agree these common principles. However, when we consider that though all these jurists, that is Jeremy Bentham, John Austin, H.L. Hart, Hans Kelsen, Holland, and Salmon, though they are from the same school, that is analytical theories or analytical school, but still there are differences or distinctions between the approaches propounded by them. Out of the 6 jurists, when we consider the views propounded by Jeremy Bentham and John Austin, there is a close similarity between the views propounded by them, whereas there were distinctions between the views propounded by H.L. Hart and Hans Kelsen. No doubt that Holland, who was a follower of Austin, therefore there is a close similarity between Austin's view and Holland's view. And Salmon, he contributed in the development of analytical school by considering that law is a civil law, and he rejected character of law which was propounded by सालमन को वो सालमन ने वो अप्रूव नहीं किया था कि नेचुरलिस्ट ने जो बोला था कि यूनिवर्सल कैरेक्टर ऑफ लॉ, तो वो सालमन को एक्सेप्टेड नहीं था. ही सेड दैट, ही रिजेक्टेड, ही सेड दैट देयर इज नथिंग लाइक यूनिवर्सल कैरेक्टर और यूनिवर्सलिटी, बिकॉज व्हाट वाज द मेन statement propounded by naturalist ki morality is a universal concept and law is based on ethics, morality and justice. But Salmon, he rejected the universal character of law and propounded the nature of law in terms of civil law. That much is sufficient. And Holland, he was a follower of Austin and he followed the ideas propounded by Austin. Now, first of all, I would like to discuss on the approaches of analytical theories propounded by Jeremy Bentham and John Austin, which are closely similar. However, still there are differences. Now, when we consider the development period for the development of these theories have been developed in 19th and 20th century. Means these are the latest theories as compared to natural law theories. These theories are latest one, and the development of these theories can be traced in 19th and 20th century, latest one. So when we consider the basic reasons or factors which are responsible for the development of analytical jurisprudence, so we can summarize in very brief, we can summarize 3 reasons. One of the reasons was reaction against natural law school. Because in 19th century, natural law school was become somewhat unpopular, and simultaneously positive law school or positivism or analytical theories started its development. Why this natural law theory or natural law school was become unpopular in 19th century, because it was a time period when it was a peak period of um, tremendous growth of new inventions and wonders in the field of science and technology. That's why the society throughout the world started thinking that due to these wonders and new inventions in the field of science and technology, now everything is in my hands, and then there is no need to believe in morality. ये मॉरलिटी वगैरह सब बकवास है, उसमें फेथ करने की कोई जरूरत नहीं है. ऐसे सोसाइटी की थिंकिंग धीरे धीरे वहां पे स्टार्ट हो गई कि देयर इज नो नीड टू पुट बिलीफ ऑन morality, or morality has become a nonsense thing, and on the basis of wonders, inventions, new inventions in the field of science and technology and wonders of science, now man is the most powerful, man has become most powerful, so there is no need of god or morality or ethics or like that, and I can conquer the world and whole world can be in my hands. That's why society started to lose lose its faith on morality, and simultaneously this positivism or analytical theories or analytical school started to get gaining of popularity in 19th century, and further development was continued in 20th century. Of course, political factor was also responsible in order to justify the commands given by monarch or sovereign authority. It was very convenient to accept these analytical theories, because without considering this distinction between legal commands and illegal commands. See, law is always legal, but commands may be classified into legal commands and illegal commands. So without considering any distinction between legal commands and illegal commands, it was very easy to accept the commands given by a monarch or sovereign or any political sovereign. It was justified within the ambit of citizens. Analytical start can be said as founder of analytical school, whereas the systematic development was further continued by John Austin, who is called as father of or originator of analytical school. Of course, this positivism work to the analytical theories or analytical approach is propounded or suggested by one of the most eminent authors in the field of jurisprudence, Dias. डायस ने ये पॉजिटिविज्म ऐसे वर्ड रेफर किया है उनके बुक में. सो दिस थ्योरी, एनालिटिकल theories are identified as positive law school or positivism or approach of positive law. Now all of you are aware that there are certain basic features or basic tenets of analytical school which are common or which are applicable to the views propounded by all the jurists belonging from this analytical school. For example, of course, analytical positivism means legal analysis and examination of man-made law. Of course, it is not a God-made law, but it is a man-made law. Because see, when we consider the basic principle or core theme propounded by jurists from natural law theory, according to opinion of naturalist, law is that law which is written in the hearts of men with the fingers of God. Means natural law was considered as God-made law, whereas positive law or analytical theories say that this law is a man-made law. It is a command of sovereign having sanction behind it. It has 4 ingredients, that is sovereign, command, duty and sanction, and it includes the legal analysis and functional approach of man-made law. It is a systematic exposition of legal system, and it places emphasis on the law as in form of command of sovereign. So these are the basic tenets of positivism or analytical theories, and I have summarized it in very brief manner because time period is very less. So these are the basic principles. No doubt that these basic tenets of analytical theories or analytical school are applicable to the views propounded by all these eminent jurists, and out of which I'm going to highlight 4 eminent jurists, that is Bentham, Austin, H.L.A. Hart, and Kelsen. No doubt that there was a close similarity between the views propounded by Jeremy Bentham and John Austin, but still there was difference or distinction, because in addition to these basic norms or basic tenets of these analytical theories, Bentham added 3 unique features of his theories which are very interesting. What were these 3 features? 3 features were that Bentham's utilitarianism, that is utilitarian theory, hedonistic calculus. He has propounded catalog of pleasures and pains, and also he has given 4 kinds of sanction. Now see what is the difference. अभी जूरिस्ट ऑस्टिन का कैसे था कि ऑस्टिन मॉरालिटी का प्लेस उनके थियोरी में मानने के लिए बिल्कुल तैयार नहीं थे. उनका कहना ये था कि देयर शुड बी टोटल सेपरेशन बिटवीन लॉ एंड मॉरल्स. मॉरालिटी के लिए उनके थियोरी में कोई जगह नहीं था. लेकिन बेंथम का अप्रोच कंपैरेटिवली बाद में थोड़ा सा लिबरल हो गया, और बेंथम ने जो 4 काइंड्स ऑफ सैंक्शन दिए उसमें से बेंथम ने मॉरल सैंक्शन नाम का एक सैंक्शन दिया है. Means what? Bentham had given some place, at least some place to the morality in his theory, but Austin was not ready to accept any place for morality in his theory at all. No doubt that सबसे पहले तो बेंथम ने बहुत सख्ताई से उसको क्रिटिसाइज किया था नेचुरल लॉ थियोरी को. बेंथम का ये स्टेटमेंट था कि natural law theory is a nonsense one containing various silly ideas within it. Bentham condemned natural law theory in very harsh manner, but he himself, after that, he himself propounded the 4 kinds of sanctions, while by considering moral sanction as one of the sanctions. मीन्स बेंथम ने तो उनके थियोरी में थोड़ा सा जगह वो मॉरलिटी को दे दिया था, लेकिन ऑस्टिन का व्यू टोटली रिजिड था. ऑस्टिन के लिए वो ऑस्टिन के हिसाब से मॉरलिटी के लिए उनके थियोरी में कोई जगह नहीं था. नो डाउट दैट इन एडिशन टू कमांड सैंक्शन थियोरी, Bentham had propounded the utilitarian theory through hedonistic calculus or catalog of pleasures and pains. उनका ऐसे बोलना था कि सोसाइटी में अगर प्लेजर का परसेंटेज या प्लेजर का इंटेंसिटी या ग्रेविटी ज्यादा हो जाता है तो इट विल रिजल्ट इनटू हैप्पीनेस एंड प्रॉस्पेरिटी इन द सोसाइटी. नो डाउट दैट द जूरिस्ट फ्रॉम वेरियस थियरीज, not only from these analytical theories but also from various other schools, that is maybe natural law theory or historical school or sociological school, no doubt that their approaches were different, their ways were different, their methods of analysis were different and distinguished from one another's approach. However, the common objective behind propounding of these theories, the common objective was that they had explained the techniques how to bring happiness and prosperity in the society. It was the common objective. No doubt that their ways were different, their logic was different, they applied different methods, but however, the common objective behind that was how to bring happiness and prosperity in the society. तो बेंथम ने भी यही बताया था कि there should be maximum satisfaction of maximum wants of maximum number of people in the society. Means greatest satisfaction or greatest happiness for greatest number of people, which was the key ingredient of utilitarian theory propounded by Jeremy Bentham, which is called as hedonistic calculus or hedonism. अभी उन्होंने वो कैटलॉग बताया था कि प्लेजर्स अगर ज्यादा रहेंगे सोसाइटी में तो इट वुड रिजल्ट इनटू हैप्पीनेस एंड प्रॉस्पेरिटी इन दिस सोसाइटी, पेन्स ज्यादा रहेंगे तो इट विल रिजल्ट इनटू सोसाइटीज कंडीशन वुड बिकम मिजरेबल। तो उन्होंने ये कैटलॉग ऐसे दिया था, जैसे कि एग्जांपल्स, हम कुछ एग्जांपल्स उसमें दे सकते कि अभी प्लेजर कौन सी बातों से हमको मिल सकता है। फॉर एग्जाम्पल, प्लेजर ऑफ रिचनेस, प्लेजर ऑफ रेपुटेशन, प्लेजर ऑफ फ्रेंडशिप, प्लेजर ऑफ नॉलेज, pleasure of social affection, pleasure from relief from pain, pleasure of good friends, etc. These are the pleasures. उसके ही अगेंस्ट अगर देखते हैं तो वो सब पेन्स है कि पेन्स ऑफ लैक ऑफ कंफर्ट, पेन्स ड्यू टू दैट इज डिसीज, or pains due to lack of skill or poverty or social boycott, or pain arising due to fear of punishment or like that. Means what? He propounded the concept that there should be greatest happiness for greatest number of people, and which can be achieved through the maximum percentage or maximum spreading of happiness in this society. And if pains are minimized in this society, then it will result into happiness and prosperity into society. उन्होंने 4 kinds of sanctions भी दिए थे, वो I shall cover in very brief. Physical sanction, political sanction, moral sanction and religious sanction. अब फिजिकल सैंक्शन उनके हिसाब से कैसे था कि विच कम्स इन ड्यू कोर्स ऑफ टाइम। अब ड्यू कोर्स ऑफ टाइम कैसे आएगा कि जैसे कि फॉर एग्जांपल कि पेन फॉलोइंग फ्रॉम ड्रंकननेस, कोई आदमी है कंटिन्यूअसली ड्रिंक्स ले रहा है तो अल्टीमेटली इट वुड रिजल्ट इनटू डिटोरिएशन और डिग्रेडेशन इन हिज फिजिकल हेल्थ, व्हिच विल रिजल्ट इनटू पेन। यानी फिजिकल सैंक्शन मींस व्हाट, व्हिच कम्स इन ड्यू कोर्स ऑफ टाइम, कि जैसे जैसे करोगे वैसे पाओगे। आपका फैमिलियर एग्जांपल एक देती हूँ कि पूरे साल में पढ़ाई की, नहीं बुक ओपन करके देखा है, नहीं तो यू विल गेट फेल रिजल्ट इन एग्जाम एज अ ड्यू इन ड्यू कोर्स ऑफ टाइम, इट इज अ कॉन्सिक्वेंस कि पढ़ाई की नहीं, कभी जैसे किया है वैसे पाओगे। फिजिकल सैंक्शन मीन्स रिजल्ट और कॉन्सिक्वेंस इन ड्यू कोर्स ऑफ टाइम। पॉलिटिकल सैंक्शन, it is attached with the will of sovereign, it is called as political sanction. For example, judicial decision है, जिसके फेवर में जुडिशियल डिसीजन लग जाता है उसके लिए वो प्लेजर होता है, जिसके खिलाफ लग जाता है उसके लिए पेन होता है। मॉरल सैंक्शन, it was resulted into concept of social boycott from the society. For example, if any person is not behaving as per the moral norms prevailing in that contemporary society, then it may result into social boycott, that is pain. तो वो आदमी को सोसाइटी के हिसाब से चलना पड़ेगा, तब सोसाइटी में जैसे मॉरल नॉर्म्स चल रहे हैं या मॉरलिटी चल रही है। अभी ठीक है, the concept of morality may change from time to time or sometimes it may changes, however the overall concept of morality is universal. तो बेंथम ने, दो ही वाज अ पॉजिटिविस्ट और फ्रॉम एनालिटिकल स्कूल, उन्होंने एक मॉरल सैंक्शन का एक कंसेप्ट दिया था कि अगर किसी आदमी का बिहेवियर अगर तब की जो मॉरलिटी है, सोसाइटी में जो मॉरलिटी चल रही है उसके खिलाफ होता है या उसके खिलाफ हो सकता है, तो उनको सोशल बायकॉट का सामना करना पड़ता है, या he may face the pain of social boycott or boycott from the society, which is a moral sanction. And religious sanction, it was attached with the concept of heaven and hell. If you are doing good things, then you will get heaven, and if any person is committing sin continuously, assigned sin, then he will go to hell. This was the concept. So I have summarized these distinguished feature propounded by Jeremy Bentham and John Austin. No doubt that there are various criticisms to this theory, because when we consider the nature, that is command sanction theory, that law is a command of sovereign having sanction behind it, तो उसमें सिर्फ फॉर्मली इनेक्टेड लॉ ही आएगा, उसमें कस्टमरी लॉज नहीं आएंगे, पर्सनल लॉज नहीं आएंगे, इंटरनेशनल लॉ नहीं आएगा, कॉन्स्टिट्यूशनल लॉ भी नहीं आएगा, क्योंकि कॉन्स्टिट्यूशनल लॉ ऑफ इंडिया दो इट इज अ सुप्रीम लॉ ऑफ लैंड, बट इट इज नॉट फॉर्मली एनेक्टेड लॉ, बट इट इज ड्राफ्टेड बाय वे ऑफ डिस्कशन amongst the constitution framers. So ऑस्टिन और बेंथम का ये जो थियरी है, एनालिटिकल थियरीज है, उसमें कस्टमरी लॉ नहीं आता, उसमें इंटरनेशनल लॉ नहीं आता, उसमें कॉन्स्टिट्यूशनल लॉ कवर नहीं होता। अपने इंडिया में के जो पर्सनल लॉज है वो तो कस्टमरी लॉज पर बेस्ड है, फिर वो कस्टमरी लॉज भी उसमें कवर नहीं होते, और उसमें जनरली कौन सा लॉ कवर होता है, जो फॉर्मली इनेक्टेड लॉ है वही कवर होता है, उसमें जजमेंट लॉ कवर नहीं होता। तो ये सब ये एनालिटिकल थियरीज का ये है, क्रिटिसिजम्स है। फिर भी एनालिटिकल थियरी का सबसे ज्यादा एप्लीकेबिलिटी और सबसे ज्यादा सिग्निफिकेंस ये है कि आज भी हम जब देखते हैं कि देयर आर 5 सोर्सेस ऑफ लॉ, लेजिस्लेशन, जुडिशियल प्रेसिडेंट, कस्टम, एग्रीमेंट्स एंड प्रोफेशनल ओपिनियन, तो आज भी लेजिस्लेशन का जो प्लेस है वो पहले स्थान पर। अभी देखिए ये जो जूरिस्ट है फ्रॉम एनालिटिकल अप्रोच, मोस्ट ऑफ द जूरिस्ट who had been contributed in the development of analytical school, they are from England, or they contributed in the development of English jurisprudence. तो इंग्लैंड में तो पार्लियामेंट्री सॉवरनिटी का कंसेप्ट चलता है, तो वहां पे पार्लियामेंट्री लेजिस्लेशंस ये मेजर सोर्स ऑफ लॉ है। या हमारे यहाँ पे भी नो डाउट दैट इन इंडिया constitutional law of India is the supreme law of land, and all the 3 organs of the state, that is legislature, executive and judiciary, are subordinate to the constitution. But still legislation is one of the most important sources of law, and when we consider the legislation as a source of law, then Bentham and Austin's theories find their place and applicability with regard to Indian legal system also. अभी ये दोनों का हो गया, ये दोनों का जो अप्रोच था एनालिटिकल थियरीज वो बहुत एक दूसरे से करीब मिलता जुलता था, लेकिन ये एचएल हार्ट और केल्सन जो थे, नो डाउट दैट दे वर फ्रॉम एनालिटिकल थियरीज और पॉजिटिविज्म, लेकिन उनका अप्रोच ये ऑस्टिन और बेंथम के हिसाब से डिस्टिंक्ट एंड डिस्टिंग्विश था। एचएल हार्ट का अप्रोच तो कंपैरेटिवली इतना लिबरल था, though he was a positivist, but he propounded the concept of minimum morality. अभी कैसे, इसके लिए टाइम बहुत कम है, क्लास में ये जब पढ़ाते हैं तो हर थियरी के लिए दो लेक्चर्स तो डिवोट कर देते हैं, तो इसीलिए मतलब ये पूरी जो 4 इमिनेंट जूरिस्ट की थियरीज है उसके लिए कम से कम इट विल टेक 10 lectures if elaborated in very thorough manner. However, here only outline I shall discuss. So वो एचएल हार्ट, no doubt that एचएल हार्ट was positivist और basically he was from analytical school. लेकिन उन्होंने क्या किया था, उन्होंने उनके थियरी में मिनिमम मोरालिटी का कंसेप्ट दिया था, इसीलिए कुछ जूरिस्ट का कोई जूरिस्ट का ऐसे बोलना था कि he is not a positivist or he is not from analytical school but he is a naturalist. Because what minimum morality का concept है, morality का concept है, means his theory finds a close resemblance with the basic tenets propounded by natural law theory. Therefore, sometimes it may seems that whether he is a positivist or naturalist, but commonly he is accepted as a positivist, that is H.L. Hart. Of course, उनका भी theory वो 20th century का था, 1907 से 1992 तक बहुत लेटेस्ट थियरी है, यानी 20। वैसे भी ये पॉजिटिविज्म की जो थियरी है वो मेनली उनका जो डेवलपमेंट है पूरा लेटेस्ट डेवलपमेंट है, 19th थियरी से स्टार्ट होकर 20th सेंचुरी में उनका डेवलपमेंट था। अभी एचएल हार्ट ने लॉ का नेचर अलग बताया, ऑस्टिन बेंथम ने क्या बताया कि लॉ इज अ कमांड ऑफ सॉवरेन हैविंग सैंक्शन बिहाइंड इट, देयर शुड बी सेपरेशन बिटवीन लॉ एंड morals. No doubt that as a positivist, H.L. Hart accepted the concept of separation between law and morals. He was with Austin and Bentham, and he accepted that there should be separation between law and morals. However, he propounded the nature of law not in the form of command sanction theory, but he explained the nature of law as a dual system of rules, that is primary rules and secondary rules. उनका अलग था, उनका बोलना था कि लॉ का नेचर है कमांड सैंक्शन थियरी में नहीं आता, लॉ इज अ कमांड ऑफ सॉवरेन हैविंग सैंक्शन बियॉन्ड इट ऐसे नहीं आता. ठीक है, एज अ पॉजिटिविस्ट आई एम रेडी टू एक्सेप्ट दैट देयर शुड बी सेपरेशन बिटवीन लॉ एंड मॉरल्स, but he propounded the concept of law in terms of dual system of rules, that is primary rules and secondary rules, and according to him primary rules are duty imposing rules and secondary rules are power conferring rules. ऐसे उन्होंने पूरा बाइफर्केशन करके लॉ का एक अलग नेचर बताया था. नॉट ओनली दैट, he propounded the concept of minimum morality by considering five ingredients of minimum morality, such as human vulnerability, approximate equality, limited altruism, limited resources, limited understanding, and strength of will. Very interesting. ये मिनिमम मोरालिटी के इंग्रेडिएंट एचएलए हार्ट ने उनके थियरी में डिस्कस किए थे. उनका बोलना था कि ह्यूमन वल्नरेबिलिटी मीन्स व्हाट, हर आदमी में कुछ ना कुछ सहनशीलता होनी चाहिए, सहिष्णुता होनी चाहिए. अकॉर्डिंग टू हिम men are not devils and should not be identified in that sense. Men are not devils and should not be identified in that sense. हर आदमी में कुछ ना कुछ तो मॉरलिटी होनी चाहिए जो उनमें इनहेरेंटली होती है. Each and every human being possesses at least minimum morality inherently in him. कहीं ना कहीं मॉरलिटी आती है. मे बी एखादा आदमी बहुत ज्यादा वो हैबिचुअल बन चुका है, रेपिस्ट है, बहुत ज्यादा सीरीज ऑफ रेप के ऑफेंसेस कर चुका है, लेकिन वो भी आदमी के सामने अगर उसकी मदर आ जाए, उसकी रियल सिस्टर आ जाए, तो वो उस हिसाब से नहीं सोचता, बिकॉज मॉरलिटी. ईच एंड एवरी ह्यूमन बीइंग possesses a minimum morality within him, which is inherent to him, and due to that, due to human vulnerability, there is observance of law. फॉर एग्जाम्पल, मैं एक सिंपल एग्जाम्पल आपको बताती हूँ कि एक ट्रैफिक सिग्नल है, ट्रैफिक सिग्नल पर सपोज 50 more than 50 गाड़ियां खड़ी है. अगर एट दैट मोमेंट अगर सबने डिसाइड कर लिया कि आई शैल ब्रेक दैट सिग्नल एंड आई शैल रन अवे, तो वहां पे जो ट्रैफिक पुलिस है या वहां पे जो भी अथॉरिटीज है कंट्रोलिंग करने के लिए, उनको वो कंट्रोल करना प्रैक्टिकली पॉसिबल नहीं होगा. सबसे पहले तो हर ह्यूमन में एक वल्नरेबिलिटी रहती है, एक सहनशीलता रहती है कि टू ओबे दैट लॉ. दैट्स व्हाई डेवलपमेंट ऑफ लॉ इज देयर, अदरवाइज इट वुड हैव नॉट बीन देयर. क्योंकि सबसे पहले तो ये है कि विल टू ओबे दैट लॉ, टू फॉलो दैट लॉ. Or men are not devils and should not be identified in that sense. There should be minimum morality which is possessed by each and every human being, and it is inherent in it. No doubt that H.L.A. Hart, he propounded the concept of minimum morality by analyzing the facts of human nature or facts related to human nature. Approximate equality. Men differ from each other in physical strength, ability, and even in intellectual capability. Even the strongest may sleep for some times, and when asleep, loses temporarily his superiority. हर कोई हर बार सुप्रीम है ऐसे नहीं होता. Even the strongest can sleep for a moment or for a while, and when asleep, he may loses his superiority temporarily. इसके लिए आपने सबने बचपन में वो रैबिट एंड टॉर्टोइज का स्टोरी पढ़ा हुआ है कि रैबिट रिमेन्स लेफ्ट ओवर एंड टॉर्टोइज वन द रेस. सो अप्रॉक्सिमेट इक्वालिटी, नो डाउट दैट men are approximately equal. They may differ in physical appearance, they may differ in intellectual capability, but their characteristics as human beings are identical or same, or as a species of animals. No doubt that biologically human beings are species of animals, so as one of the species, that is as a human being, they are equal. Limited altruism limited selfishness or unselfishness. Again, I shall quote that example. Men are not devils dominated by a wish to destroy completely each other, and men should not be identified in that sense. आदमी की हमेशा ऐसी इच्छा नहीं रहती ऑल टाइम कि दूसरे को डिस्ट्रॉय कर देना चाहिए, दूसरे का बुराई होना चाहिए, या ऑल टाइम ऐसे नहीं होता. Men are not devils and they are not with the wish to destroy themselves. कभी कभी उनके लिए भी मतलब अच्छाई उनमें कुछ ना कुछ होती है. जैसे कि एक आपका फैमिलियर एग्जांपल में फिर से बताती हूँ कि यू मे थिंक दैट कि आपका जो बेस्ट फ्रेंड है, ठीक है, मेरा रैंकिंग वो एग्जाम में फर्स्ट आना चाहिए, उनका फिफ्थ के बाद आना चाहिए. लेकिन आप ऐसे तो नहीं सोचते ना कि मेरा फर्स्ट आना चाहिए और उनको सभी सब्जेक्ट में 0 स्कोर आना चाहिए. इतना बुरा नहीं सोचते. मीन्स कुछ ना कुछ तो आदमी में अच्छाइयां रहती है, कुछ ना कुछ वल्नरेबिलिटी रहती है, सो दैट लॉ शुड बी ओबेड, लॉ शुड बी डेवलप्ड, लॉ शुड बी फॉलो. लिमिटेड रिसोर्सेस. देखिए, अभी हम सेव पेट्रोल, सेव ऑयल बोलते हैं, वो एचएलए हार्क ने पहले ही बोल दिया है कि रिसोर्सेस आर वेरी लिमिटेड, नेचुरल रिसोर्सेस एज वेल एज अदर रिसोर्सेस, and men have to develop themselves through limited resources. Resources should be preserved and prohibited for future generations. Limited understanding and strength of will means how to establish social life, how to behave in society, how to respect the wishes of this society while maintaining our behavior in this society. All these analysis was propounded by H.L. Hark, and when we consider all these analysis, that is concept of minimum morality, this concept of minimum morality is having close resemblance with modern human rights jurisprudence in 21st century, because human rights are also the rights considered as inherent in nature, and observance and development of human rights is based upon the concept of minimum morality observed by the human beings, so that there should be development of human rights in 21st century. Means there is a close resemblance between the H.L. Hart theory and modern human rights jurisprudence in 21st century. Therefore, H.L. Hart's theory, it is relevant and significant in today's age or in present age. Of course, Austin Bentham's theory is also significant when legislation as a source of law is considered. Till today, legislation is one of the important sources of law, and in that sense, this theory is acceptable. Now, last one, that is Kelson's concept in brief. अभी Kelson का view था, in that comparison view propounded by jurist Kelson regarding separation between law and morals was much rigid, much more ऑस्टिन ने तो सेपरेशन बिटवीन लॉ एंड मॉरल्स का ही कंसेप्ट दिया था, बट हैंस केल्सन he went further to that, and he propounded that there should not be separation between law and morals, but there should be separation of law from all other elements, that is ethics, morality, history, biology, sociology, psychology, etc., etc. And Kelson propounded that these all are impurities, and there should be total separation between, not only between law and morals, but also between law and psychology, sociology, ethics, morality, biology, history, psychology, etc. जो कि पॉसिबल नहीं है, जो कि प्रैक्टिकली पॉसिबल नहीं है. प्रैक्टिकली इसीलिए पॉसिबल नहीं है कि हिस्ट्री का इम्पैक्ट तो लॉ पर आएगा ही, सोशियोलॉजी का इम्पैक्ट लॉ पर आएगा, साइकोलॉजी का इम्पैक्ट लॉ पर आएगा. अगर साइकोलॉजी का इम्पैक्ट लॉ पर नहीं आता था या मैनमेड लॉ पर नहीं आता था, तो आपको वर्ल्ड में सभी कॉन्स्टिट्यूशन या सभी लीगल प्रोविजन सेम दिखते थे. वो सेम नहीं दिखते, वो अलग अलग दिखते हैं, क्योंकि वहां जो भी उनके जो भी मेकर्स है, कॉन्स्टिट्यूशन मेकर्स है, या जो भी ड्राफ्ट कर रहे वो लॉ को, उनका साइकोलॉजिकल इम्पैक्ट, सोशियोलॉजिकल फैक्टर्स, हिस्टोरिकल फैक्टर्स, वो सब अलग अलग होते हैं. दैट्स व्हाई द लीगल सिस्टम्स इन द वर्ल्ड contains the provisions which are different and distinguished from one another, otherwise it would have been remained almost the same. So separation between law from morality or ethics or history, biology, sociology, psychology, it is practically not possible. But Kelsen propounded this concept in terms of Kelson's pure theory of law. Kelson's pure theory of law, and he propounded for the total separation not only between law and morals, but between law, ethics, morality, psychology, history, biology, sociology, etc., etc. And he propounded that politics, etc. He propounded that all these things are impurities and we should not be mixed with laws, with the law at all. Not only that, he propounded the concept of grand norm, that is apex norm. Grand norm, according to Kelsen, grand norm is a norm, apex norm with highest rank of sanction. Now, when we consider this concept of grand norm or applicability of grand norm with regard to Indian legal system, then constitutional law of India is apex norm, and all the three organs of the state, that is legislature, executive and judiciary, are subordinate to them. When we consider the hierarchy of legislation in India, then parliament or legislations enacted by the parliament, or of course when we consider the executive or hierarchy of executive, then constitutionally the president shall be the head of executive. Judiciary, that is Supreme Court of India, headed by the Chief Justice of India. Means like that, means when the hierarchy is drawn, the concept of grand norm can be considered, because when we consider the hierarchy of judiciary, the judicial precedents, that is when we consider the judicial pronouncements propounded by Supreme Court are with highest sanction in the judicial field, or Supreme Court of India is the apex judicial organ, whereas high courts and lower courts are below that. Means in that way, the concept of grand norm propounded by Hans Kelsen, it is applicable with regard to present Indian legal system. However, practically, the purification of law or total separation between law, morals, ethics, sociology, psychology, history, it is not possible. It is not possible, or purity of law is impossible. So these were the various theories propounded by various jurists from analytical school. No doubt that their ways behind propounding the theory were totally different, were quite different, or there are the variety of their study or analysis or logic applied behind applied for the development of analytical theories. However, when we consider the thorough analysis, or when we go the thorough study through their theories, then we will definitely conclude that the ultimate object behind the development of these theories was one and the same, that how to achieve happiness and prosperity in the society. ठीक है, ऑस्टिन का व्यू ऐसे था कि कमांड सैंक्शन कर दिया, पनिशमेंट प्रिस्क्राइब कर दिया, तो सोसाइटी में लॉ एंड ऑर्डर आएगा, हैप्पीनेस आएगा. बेंथम का बोलना था कि ठीक है, वो कमांड सैंक्शन थियरी तो है ही, लेकिन वो मॉरल सैंक्शन भी चाहिए, कैटलॉग ऑफ प्लेजर्स एंड पेन चाहिए, रिलीजियस सैंक्शन चाहिए, पॉलिटिकल सैंक्शन चाहिए, वो अलग अलग. बट हाउ टू ब्रिंग हैप्पीनेस एंड प्रॉस्पेरिटी इन दिस सोसाइटी, एचएलए हार्ट का बोलना था कि मिनिमम मॉरलिटी सबने फॉलो कर ली, या प्राइमरी रूल्स और सेकेंडरी रूल्स का अच्छे से कॉम्बिनेशन रहा और कोऑर्डिनेशन रहा, तो इट विल ब्रिंग हैप्पीनेस एंड प्रॉस्पेरिटी इन दिस सोसाइटी. हेंस केल्सन का बोलना था कि प्यूरिफिकेशन ऑफ लॉ कर दिया, लॉ सबसे सेपरेट कर दिया, और ग्रैंड नॉर्म का कंसेप्ट अगर हम फॉलो करते हैं और ग्रैंड नॉर्म के हिसाब से अच्छे से चलते हैं, तो इट विल ब्रिंग हैप्पीनेस एंड प्रॉस्पेरिटी इन दिस सोसाइटी. नो डाउट दैट द वेज propounded by these jurists from analytical school were different, but their ultimate object was same, that is how to bring happiness and prosperity in the society, how to maintain order in the society, how to maintain peace and security in the society, so that it will result into comfort and welfare of the society. And when we consider the overall applicability or overall application of these theories, no doubt that Austin's Bentham theory is applicable when we consider legislation as a source of law. HLA Hart's theory is applicable when we consider the modern human rights jurisprudence and its applicability in India. Of course, we are considering applicability in India. And when we consider the Hans-Kelsen's theory, then the applicability of grand norm and hierarchy of all these three organs of the state, that is legislature and executive and judiciary, is there. So in short, no doubt that they have analyzed these theories in different way, but the ultimate aim was to bring happiness and prosperity in the society, to bring comfort, and to ultimately the happiness and prosperity in the society would result into the welfare state, which is still relevant and significant under Indian legal system, and it is also one of the ultimate goal to be achieved by the legislature in India. Therefore, these theories, analytical theories, are valuable and significant in present age also. So, अमोल सर वेळ झाला आहे का? Shall I?
Oh, madam. Yes, ma'am. Please, you conclude the lecture.
Yeah. So,
I think
yes. So, yes. Means
Yes.
conclusion is the same, that applicability with regard to Indian legal system. No doubt that mostly these theories are developed by English philosophers or philosophers from England. For example, when we consider, that is Jeremy Bentham, who Jeremy Bentham and John Austin, they are considered as founder and father of English jurisprudence. No doubt that they developed their theories in the norms prevailing in England or in UK, that is with the doctrine of parliamentary supremacy or parliamentary sovereignty there. H.L.A. Hart, British legal philosopher, Hans Kelsen, he contributed his work in United States of America. Salmon, he was also from England. Means mostly the analytical theories are developed by the English philosophers or English jurists by considering the nature of English legal system or legal system in Britain. However, as there is a close resemblance or similarity between British legal system and Indian legal system with adoption of parliamentary form of government in India, no doubt that in India there is no concept of parliamentary supremacy or sovereignty, but constitutional law of India is the supreme law of land. However, the authority to amend the parliament is entrusted with the authority to amend the constitution is entrusted with the parliament, which has been delegated or entrusted with the parliament by the constitution itself by through a provision under article 368 of Indian constitution. Therefore, even no doubt that parliament is not supreme, or there is no concept of parliamentary sovereignty or parliamentary supremacy in India, but still parliament is entrusted with the authority to amend the constitution, of course subject to basic structure theory. But in that sense also, these analytical theories are developed by the English philosophers or English jurists or experts, but these theories are significant and applicable with regard to Indian legal system, and these theories are in coordination with the concept of welfare state. So with this, I want to conclude my speech. I am thankful to Dr. Amol Chavan and organizers for giving me an opportunity to share my views with you. Of course, these theories are, I have already told you, that very bulky, and it become possible for me just to cover the outline. Thanks, Dr. Amol and principal, vice principal, and IQC coordinator of this college. Thanks to all, and thank you, students, for your patient hearing, because jurisprudence is much a technical subject, but you are there, and you means I'm thankful to you for your patience.
Thank you so much, ma'am, for making this session meaningful and very interesting with your great knowledge. Now I request our respected Vice Principal, Professor Sri Krishna More, sir, to propose the vote of thanks. Over to you, sir.
Thank you, Prashasti. I hope I am audible.
Yes, sir, you are audible.
Okay, thank you very much. It is really wonderful experience with respected Dr. Bhagyashree Deshpande Madam, Professor Punjab Rao Deshmukh, Law College, Amravati, who had very lucidly deliberated on the analytical theories of jurisprudence. Madam have really pointed out that it is very difficult task to discuss these all analytical theories within a span of 1 hour only. But even then, ma'am has given justice to the topic, and I can confidently tell that it will be really useful for the student from the rural area of the country, and as well as the student of the urban areas, because madam have taken the care while deliberating on the topic and see discuss in English as well as in Hindi. So due to this reason, I am thankful to Dr. Bhagyashree Deshpande Madam for delivering this very resourceful lecture in our 1 week online lecture series on jurisprudence. With this, again, I will request all the participants, please attend this lecture series daily and take the benefit of the knowledge of the resource persons. I am also thankful to the management of our Marathwada Legal and General Education Society for permitting us to hold this lecture series. Our respected principal, Dr. C.M. Rao sir. I am also thankful to my co-coordinators, Dr. Amol Chavan sir, IQAC coordinator, Dr. Aparna Kotapalle madam, and all the participants who have joined this endeavor and shown their presence into this August gathering. At last but not least, I must again appreciate the effort taken by Prashasti or anchor, who have in a very good manner tried to anchor this first lecture of the 1 week lecture series. With this, I'm again thankful to one and all. Thank you very much. Yes, Prashasti.
Thank you, sir. And I express my best wishes and blessings to all students for their bright career development in future. Thank you, sir. Thanks to all. Thanks, dear student. Thank you.
Thank you so much, ma'am. Thank you so much, sir. Before ending this session, I request to all the attendees to remain present tomorrow at the same time, where Dr. Arvindnath Tripathi, Research Assistant of DSNLU, will be addressing the session on the topic of conspectus of jurisprudence. So stay tuned, stay safe. Thank you all.
Thank you. Now we are going to end this meeting. Thank you very much.